Our two speakers today, Monty Taylor from 10th Floor Chambers and Dan Ullman, who's a fellow partner of mine at Norton Rose Fulbright. I'm sure Monty and Dan are very well known to most people on this call, but just by way of a very brief introduction, Monty is a barrister, as I said, at 10th Floor Chambers here in Sydney. He maintains a broad commercial practice with a specialisation in international arbitration and has extensive experience representing individuals, corporations and governments in disputes across a wide variety of industries. Prior to joining the bar, Monty was a partner in the London office of a major US law firm, where he acquired nearly a decade of advocacy experience in complex and high-value disputes, conducted under all of the major arbitral rules, including ICSID, UNCITRAL, LCIA and ICC. And particularly pertinent to today's discussion, Monty also previously served as legal counsel at the World Bank, ICSID, in Washington, D.C., so is very well placed to speak on the topic today on the case for and against ISDS reform. Dan Ullman, likewise, is very well qualified to speak to today's topic. He specialises in cross-border disputes and represents clients in international commercial and investment arbitration. Prior to joining NRF, Dan also practiced overseas in New York, where he focused on international commercial arbitration arising out of projects in Latin America and investment treaty arbitration related to conflicts in Eastern Europe, which remains very topical. So without further ado, I will hand over to Monty and Dan to kick off today's episode. People are very welcome to submit questions. We might hold those until the end, and then you're welcome to raise any thoughts or questions with Dan and Monty. Over to you. Thank you.
Well, thank you very much to the ICC Australia Arbitration Committee for the kind invitation to participate in this conversation series. I think this is a great initiative for bringing together the ICC Australia community and the arbitration community more broadly. And so we're grateful to Jacqueline Lau from the Australian Chamber of Commerce and Industry for all her efforts in coordinating, to Emily Hay for proposing a great topic, and to Tamlin for being generous enough to ask Monty and myself to be involved. As you heard, the topic for today's episode is ISDS, the cases for and against reform. So Monty, you and I are going to focus this conversation on the reform process underway at UNCITRAL and in its working group number 3. For those who don't know much about it, UNCITRAL is part of the UN system. It was created by the UN General Assembly. It focuses on trade law. It has a commission, which is made up of about 60 member states, which is like the decision-making body. And the commission reports to the General Assembly and also oversees these various working groups. There are 6 of those set up to address different aspects relevant to trade law, and we're interested in the working group that's addressing investor-state dispute settlement. The official mandate of UNCITRAL is to advance the progressive harmonisation and modernisation of the law of international trade, and usually it does that in 2 ways. One is through model laws, which are used to harmonise domestic laws, and the other is through conventions. So putting to one side, Monty, the merits of particular reform proposals, what are your views on UNCITRAL, which is a multilateral forum of states? What are your views on that being the place for having this reform discussion?
Well, thanks for the question, Daniel, and please allow me at the outset to join in your thanks to the ICC Australia and of course to Tamlin and Norton Rose as well. So I had the pleasure of being at one of the first meetings of Working Group 3 back in 2017, I want to say. And what was really memorable about that time, and I think stays with me as I think about your question, is that the process very much felt like one of healing and for states, but also recapturing control and initiative in respect of a system that, at least as a matter of perception, and perhaps there's some truth in the reality of it as well, was being managed or otherwise benefited managed by or only benefited investors. At least that was the perception at the time, part of the quote-unquote backlash against the investor-state arbitration system, where you had these multitude of treaties with consent to arbitration waiting there to be taken up by investors, including a suite of potential arbitral options that an investor could choose. And then states being, in some cases, surprised by these arbitration agreements down the line. And of course, the nature of the substantive protections being provided to investors as opposed to states. And then investors, in turn, being, in practice, the only parties that really could benefit from arbitral awards at the end of the process, led to this perception that it was a process for foreign investors, as opposed to a process and a system that is made by the states and emanates from the state's consent. So at a broad level, there was something, in a sense, lovely about watching states, and important as well, about watching states come together to have that forum and that space to be able to discuss in a free and open way their concerns about the system and ways in which to reform it. And this is not to pour scorn on the topic at hand in terms of pros and cons of the reform proposals, but in a sense, I've always seen it as somewhat immaterial, because ultimately this is, and not uniquely, but it's certainly unusually, a system of law that is made by the states and could go away if the states chose to remove it. So if the reform proposals that are at issue are acceptable and palatable to the states and a plurality of states, then there's merit in itself in those reform proposals going forward. Because ultimately, the only question that really matters is what do the states want, and does the reform proposal at issue achieve it? Briefly on your point with respect to the multilateral forum, there's always been some interesting dynamics at play within the system as to multilateralism versus bilateralism. And this is, of course, a push or potential push towards multilateralism to address issues. It has been a system that's highly flexible and adaptable, where states can, on an ad hoc, treaty-to-treaty basis, address concerns, adjust language, and it operates that bilateral flexibility within these multilateral, and not just within, but alongside these multilateral instruments such as the ICC Convention, New York Convention, and the like. It is certainly a shift, or a potential shift, to see these reform considerations being taken from a bilateral ad hoc arrangement and put into this systemic environment, and potentially being dealt with as a matter of consent amongst the plurality of states. Of course, there are states that are in opposition to that and would wish to retain the bilateralism and the flexibility of that approach that still exists within the system.
Yeah, I think, one thing in response to your observation about flexibility is that the UNCITRAL working group, at least, has been really clear about distinguishing between what it refers to, whether it's a sensible distinction or not, between procedural and substantive issues. And it says quite clearly it's only looking at procedural issues. So, for example, the independence of arbitrators, that's a procedural issue, but the formulation of FET, fair and equitable treatment, that's a substantive issue. So it's not part of this body of work. So, I do wonder whether maybe there's enough flexibility built into whatever these outcomes are, just by virtue of the fact that the substantive issues are still determined by those myriad bilateral treaties, much more bespoke. And so there won't be uniformity at the end of the UNCITRAL process in the sense of a single body of legal standards, to the contrary, just in the sense of procedure. Even as I say that, I recognise there's a separate piece of work at the OECD, the Track 2 process, and that is about updating and aligning the substantive treaty clauses. So maybe I'm offering false comfort, and the focus on substantive issues is just going to be the next step in this evolving reform program?
Well, it's a good point, and I should add that the loss of flexibility is not necessarily a bad thing, as and in the context of not that I'm suggesting that that the reforms under consideration at UNCITRAL result in a lack of flexibility on substantive standards, but even if it's on a procedural basis, there's consistency, there's predictability, stability, there's safeguarding for states that comes with that decrease in flexibility, but a more homogenized or singular approach to an issue. The only point I make on the substantive procedural divide, for what it's worth, is, and I don't want to anticipate our discussions around investment courts and appellate bodies and the like, but it does, I think, create some interesting frictions between the idea to create a form of precedent or hierarchy within the investment arbitration system, to have case law being determined and binding case law on particular standards, which, whilst it's a procedural mechanism, it would result in a substantive outcome. And the ways in which that works alongside BCLT treaty interpretation obligations of those of the court, if ever established, and the appellate body, and the ways in which states would still be able to adjust their treaty language in order to ensure that there is that ability to change meaning within treaties, or whether the case law of a court and appellate body might, in a sense, circumscribe the ability of states to be able to adjust substantive standards. But it's a conversation perhaps for later, but I think one of the interesting issues as to substance versus procedure within this process.
Yeah.
But that takes me to a different point arising out of some of the procedural proposals that are under consideration, and that's the ongoing discussion and quite far along discussion of the creation of an ISDS advisory centre. And we've seen that process is fairly far along. And I wanted to ask you, Dan, could you tell us a bit about the background to that centre, and to the extent you feel you're able to, given it hasn't been established as yet, how it might operate in practice?
Yeah, thanks, Monty. So the background is that this is an idea that grew out of experience with a completely separate type of international economic law dispute, being the WTO, trade disputes before the WTO, because there is an advisory centre on WTO law, which is referred to as the ACWL, and that's an intergovernmental organisation. It was established in 2001 because it was acknowledged that whereas most developed countries had pretty sophisticated in-house legal expertise to help them understand WTO law and participate in the WTO system, most developing and least developed countries did not. And so those countries can approach the ACWL for services like free advice on procedural or substantive issues of WTO law, assistance in WTO disputes before a regular panel or the appellate body, so free of charge in the case of a least developed country, or for a modest fee in the case of a developing country. And the centre also provides training on WTO law and procedures, and it hosts secondments for government lawyers, that sort of thing. So the question was, well, why isn't there something similar for ISDS disputes? And so there was a process for establishing a similar body. And there was a lot of discussion about whether the centre in practice should be primarily about a capacity building resource, so providing education and training and technical expertise on the ISDS system, or alternatively, a provider of legal advice, particularly to parties without the means, whether they're logistical, financial means, to engage those services in the private market on the scale that they would need to defend themselves. So the second role was more controversial, but that is what was ultimately adopted as a key function of this advisory centre. As you sort of hinted at, Monty, that this is one of the reform ideas that's actually quite far along now, because in July last year, the Commission at UNCITRAL adopted, in principle, a statute that establishes the advisory centre, and the statute does include provisions that would allow the centre as a practical matter, to act as a legal representative of its members in an ISDS dispute. So yes, providing advice, but also, preparing pleadings, representing states at hearings. So in summary, it's a new body. It did not exist before. It will be set up to assist developing and least developed countries to navigate international investment disputes. It was modelled on that experience of the WTO Advisory Centre, but there are important differences between the WTO system and WTO disputes and the ISDS system. And so in practice, we might expect that will affect what a body like this will actually need to do.
Yes, and just from a pure practical perspective, the number of cases that we see in the ISDS sphere each year, the length of time that they run for does, perhaps shouldn't speak as to average time of cases in that respect, but it does seem like it would be a very significant undertaking to set up a body like that was able to provide real and effective assistance to multiple states, and perhaps it becomes at least at the outset an option for the smaller states or developing states that rather than it being an opportunity and a resource for a larger number, but perhaps it grows over time.
I think it's definitely right that resources will be an issue. Even the statute that's been established has in it that the services that are actually going to be offered in practice will be subject to the resources available, and the resources available will be through contributions from members. So that will depend on the development level of a state. It can come in the form of donations, but the funding mechanisms all raise their own questions. That hasn't been ironed out yet. So certainly the big practical question mark, I guess, about how the advisory centre will operate stems from funding and the resources that will realistically be available. So the advisory centre, I guess, is a modest structural reform to the ISDS system. It adds something that wasn't there before, but I want to move on now to another structural reform option that could be more impactful than that. It's the option of establishing a multilateral investment court, or at least a standalone appellate mechanism. So, Monty, how is that sort of idea being received?
Well, I can see from some of the initials in the team's call that there are many here that know very well how this has been received, and have heard many people comment upon it. It's been a remarkably interesting but also divisive prospect and proposal that's been, in particular, voiced and pursued by the EU over the past years. I think I gave a talk about the CETA investment court idea, or at least bilateral investment court in that case, back in 2015. So it's not a new idea in that sense, but it's still at that nascent phase of its development. So it's been divisive, but also because of how heavy hitting some of the voices have been on this issue, having the EU have such a strong position in favour of its creation of a multilateral investment court, including an appellate body on top of it, or as part of it, I should say, and then having the US, rightly or wrongly, considered as being in opposition to that, and favouring a less systemic reform to the system. But as a matter of objectives and theory, it's hard to argue against the court and an appellate body in addressing the concerns that have been raised in the context of the Anti-Trial Working Group meetings, in terms of double hatting, ethical concerns about arbitrators having other roles, whether that's as counsel or experts or perhaps even otherwise. Of course, concerns around consistency in jurisprudence, having a form of precedent introduced into the system would serve to provide a level of consistency, or at least in theory would serve to provide a level of consistency and predictability in terms of how states should approach regulation and action within their own jurisdiction, their own territories. keeping an eye on what might happen afterwards. So all of the concerns, not all of them, I shouldn't say that, but a number of the concerns raised in the context of the Australian Working Group meetings and generally as part of the concerns about ISDS are at least theoretically addressed through these systems. But again, we come back to this point about consent, and if the states want this, then they should have that because it's ultimately a system that's for states by states, and of course it's for investors as well, but it's a system that emanates from the consent of states. So it's an answer in itself in a sense, but as practitioners we always do find ourselves thinking about the practical consequences of some of these proposals. And as a matter of efficacy, there are a number of issues where at least I question how things will play out in practice. The most obvious one, at least for me, is with respect to the appellate court and the way in which a precedential system would work. It certainly makes sense with respect to commonly litigated instruments of consent or multilateral or bilateral agreements that come before a court and an appellate body, where, for example, the ECT, perhaps not the best example given how things are going on that front in terms of states leaving it, but we have these repeat players as treaties that are constantly or regularly coming before tribunals. And in that circumstance, having a consistent body and binding body of jurisprudence with respect to those treaties could certainly be helpful for both advocates and for states. I shouldn't just say advocates selfishly, but clients in determining how to approach issues both in thin cases, but also in how to act as a state and as governments. But the complexity arises when you realise and consider how many of these instruments will presumably come before such a court if it is created. And subtle distinctions in language, context, object and purpose will necessarily affect the Vienna Convention analysis that would have to be undertaken by the court and appellate body. So you could end up with these circumstances that perhaps wouldn't be desirable, at least in theory, which is where, from the perspective of seeking to resolve inconsistencies or create consistency, where you might have similar language in different treaties that are interpreted in different ways, adopting a totally legitimate and appropriate Article 31 analysis under the VCLT. So there's those sorts of considerations just in the granular operation of the court and appellate body that I consider, but also just as a practical matter, thinking about what an appellate system is also designed to do, which is to provide an opportunity to appeal from underlying decisions. That all sounds great if you lose, but if you win, and states do win cases, the prospect of having to face a rehashed version of the claim that they just defeated at the underlying stage is not particularly palatable, I'd imagine. So as a practical matter, there may be greater concerns in the implementation of some of these reforms for the states that are currently advocating for them. But what is, I should add that on the rehashing point, that would also be subject to the scope of the review or the scope of the appeal that's available. And certain versions of appellate body or court statutes that I've seen have been relatively closely aligned with annulment standards, for example, and New York Convention style review grounds. So in that circumstance, you'd be perhaps not looking at quite the same level of potential mischief in having a lengthier or overly used version of an appellate system. But what is a great aspect of the UNCITRAL process is you see the states working through these practical consequences or potential consequences and seeking to resolve them through drafting and through concessions and approaches through reports and statutes. So you're seeing the problems or potential problems being addressed in real time.
Yeah, well, I think working through is the right way to put it, a polite way to put it. I mean, it is interesting. There is a lot of working through, and it's good that it's transparent. It does highlight that the largest hurdle, I think, for this reform option is all around political will. For an investment court to emerge that's truly global, it's going to need a critical mass of states to commit to moving from the current ISDS system to a court, and that's going to require a new convention that's widely adhered to and it will require the amendment and replacement of hundreds of existing international investment agreements. So on this option, there is still a lot to look forward to watching the working through.
Yeah, certainly. And I recognise we're getting near the end of our time, but there was another aspect of the reforms I wanted to discuss with you, which is probably the furthest along with the reforms, which is the Code of Ethics, which I picked up a 48-page binder of it recently, which I think is double the length of the original hunter trial rules. The actual code is relatively short, but gave the sense of a much lengthier document. But I wanted to ask you your thoughts on the code, and in particular whether you've seen it adopted, applied in practice, whether parties are pushing arbitrators to adopt it.
So, as you said, this is another reasonably concrete development, not a draft statute or a working paper, but we actually have a code of conduct. It has been published by UNCITRAL. It has been approved by the UN General Assembly at the end of 2023. There are actually two codes. There's one for arbitrators. There's another one for judges. The code for judges is meant to be used if a standing mechanism is eventually established. But we're just going to focus for now on the code for arbitrators, which already has application. So the last reform option we looked at was about addressing coherence and consistency in decisions. This is trying to solve for a different problem. This is about concerns around independence and impartiality. In terms of how it applies in practice, probably the most important innovation in the code is what you mentioned, Monty, the reference to double hatting. Double hatting is about arbitrators taking on multiple roles. And so in the ISDS context, that means the arbitrator either simultaneously or within a pretty short period of time assumes two distinct roles in different cases. The most common concern we hear about is a practitioner who sits as arbitrator in one case and then counsel in another case. But the concern could also involve arbitrators taking on other roles like being an expert witness or a mediator. Now, at one end of opinion, there has been a strong push to just prohibit that altogether. If you want to sit as arbitrator, you can't take on cases as counsel in the same way that a sitting judge wouldn't pop up on occasion acting on behalf of a party in another court. But the code doesn't take that position. It has landed on more of a compromise. Instead, the double hatting article says it applies to three scenarios of related cases. Cases involving the same measure, cases involving the same or related parties, and cases involving the same provision of the same treaty. And it imposes three new limits. For an ongoing role as arbitrator, a concurrent role, it says an arbitrator cannot act in another case involving any of those, same measure, same parties, same provisions of a treaty. In terms of a past role as arbitrator, there's a 3-year limit and a 1-year limit. The 3-year limit is for acting in another case that either involves the same measure or involves the same parties. The 1-year limit is for acting in another case that involves the same provisions of a treaty. And in all those scenarios, the parties are free to agree otherwise. So by adopting a compromise approach, the code is trying to balance party autonomy with clear restrictions on multiple roles. And that, in answer to your last question, I haven't seen it yet operating in an actual case. That makes sense. The code only applies where parties either consent to it or it's required by their instrument of consent, like the bilateral investment treaty with the ISDS provision. So, the real impact of this code is more likely to be felt when a new wave of treaties emerges that refer to it in the instrument. But what about you, Monty? You said you'd printed it off. So have you seen it adopted and operating in practice?
Well, what I'm hoping for is getting one of the actual little binders, those beautiful little books that you have to be at the institution to pick up a copy of. If I was in Singapore, sadly I'm not at Convention Week, then perhaps they're available for pickup. But I haven't seen it in the case that I've been involved in recently, because presumably it would require the parties, as you say, to either agree to it before the tribunal is constituted, or to speak to the tribunal about it in the context of procedural sessions or thereafter. I have seen it, though, used as a sword in challenge-related submissions. Another potential point of ammunition in making arguments about independence and impartiality. But yes, in my experience, I haven't seen it adopted formally in a case I've been in.
Well, I think, Monty, that brings us to the end of the sort of 4 topics that we wanted to have a chat about. And I haven't seen any questions pop up from the floor, but maybe we throw it open in case anyone has observations, points they disagree with, questions to put out for further discussion.
Thank you so much, Monty and Daniel. I had a little question, which was this International Advisory Centre that you've introduced us to as a way of giving advice and resources. Is the focus exclusively on advising states or making that available to states, or would it also be available to potential investors?
Exclusively to states.
Okay, interesting. Yeah. Thank you.
Hi guys, I have a quick question. Can you hear me okay?
Yeah.
Excellent. Thanks so much for a great presentation. I've been a little bit behind on my ISDS reform reading, so that was really helpful. A question about the advisory court. Last time I looked into this, which was a few years ago, the proposed salary for the judges was something like 90 euros or so an hour. Does that ring a bell? Have they, because what impact will that have in terms of the quality and quantity of people who you will get applying to be a judge on these investment courts? And did that come up in your preparation for today?
Well, so I haven't looked at the latest numbers, but I do recall that discussion a few years back when the original figures were put out, and everyone's, particularly people in your position as established arbitrators, everyone's head went back because of the nature of this court. You're looking to, and this is, I think, an open question still under the latest papers, but it's ideally for full-time or part-time members. But it's certainly for full-time arbitrators / judges. So there is, if you are going to attract the sort of quality of decision maker that they want to have, it has to be financially viable. But as of my most recent research, I didn't see anything specific in terms of higher numbers. I think it's remained relatively flexible, and I think carefully so as they narrow down the relevant and harder issues to deal with. But I haven't seen a specific number bandied around since we saw those earlier ones. But I'm not sure if Dan has seen updated information.
No, that's the same as what I've seen. It's a great question, Lucy, and I think there's we won't know for a little bit of time where that is going to land, but it's obviously potentially a cause for concern.
Thanks very much.
Can I ask a question? Sorry, it may have been lack of attention, but where do you find this code for arbitrators? I'm just looking on the ICSID website and I can't sort of put my finger on it. You might have downloaded it and found 48 pages, but where do I get it?
It's actually, it's on the UNCITRAL website. I can drop it in the chat for this group so that people can take a look and you can download a copy there. On the UNCITRAL website, not on the ICSID website.
Thanks. Sorry.
Yes, Judge. You won't have to comply with it when you're next appointed unless you're told to. So, and ICSID won't make you do it, at least for now.
Thanks.
A quick question from me, perhaps self-interested. Have any of these reform suggestions touched on enforcement, or is that being left entirely to domestic laws?
Tamlin, I haven't seen any of these reform discussions address the issue of enforcement. I'm not sure. In your self-interest, do you have a view on that?
Well, it's connected with another observation, which is one of the things that jumps out at you when you look at these cases is how long they take to run, to resolve. And then if you have an enforcement stage on the top of that, it adds multiple additional steps and years to the process.
we'd be familiar with the emphasis in this world of international commercial arbitration is to efficiency and speed and cost effectiveness. Is any of that sort of translating into the debate about ISDS reform?
Well, the only point so I, like Dan, I haven't seen a great deal of discussion. Equally, I'm not poring over all of the interventions by each state representative at the working group meetings. So when I'm lucky enough to attend, I listen, but otherwise I'm reading the summaries. But in terms of the material that's being produced by the working group, it's not a focus, but there are occasionally crumbs of reference to a concern as to enforcement. And a classic example of this is, I believe, the concern around whether judges on a court would be considered able to produce arbitral awards, arbitration awards, and requirements, or not requirements, but those being a part of the working group process, considering the potential ramifications as to enforcement under the New York Convention and other instruments in terms of, or in particular, the New York Convention, with respect to a process that is determined by standing judges rather than by ad hoc appointed arbitrators by the parties under whatever system of constitution is set up. But Dan and I have discussed this in a different context, so I'm not sure if you have anything to add specifically on that point.
Yeah, that was a concern around the proposal for a court, and I think it's been addressed, at least, or has been sought to be addressed in the EU's draft statute for establishing the court, to specify that it will be treated as an award for purposes of the New York Convention and enforcement. So yes, you're right, crumbs of it in that context, Monty.
Thank you. Were there any additional questions from attendees? No. All right, then, just in light of the time, I'd like to extend a vote of thanks on behalf of ICC Australia, and particularly the Arbitration Committee. That was really interesting. I learned a lot. Thank you. It was very succinct, but covered a lot of ground. So we really appreciate your time and your insights today.
Thank you.
Thank you.
Thanks, everyone.
Thank you. Good to see you.